Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and we have a huge docket today. First, Jussie Smollett is back in the news. Why, you say? He just got indicted. Second, Micheal Avenatti's extortion trial in New York City is coming to an end. Third, Harvey Weinstein's defense rested today. Fourth, Fotos Doulos' attorneys got threatened and somebody got arrested. Fifth, Brandon Clark pleads guilty. Sixth, Roger Stone's prosecutors quit in protest. And finally, our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thank you for tuning in. If you have not already subscribed, boy, we would sure ask you to do so. Hit that little like button and leave us a comment. We want to know what you have to say. And I don't know if you can tell, but I feel a hell of a lot better today after recovering from all this skin cancer stuff. I just wasn't with it yesterday, so we're in it today. First on the docket, Jussie Smollett just got indicted. What? For what, you might say? Well, Jussie Smollett's case had a huge twist. For those who don't recall, Jussie Smollett basically fabricated a story that he was beaten. He alleged that it was racially motivated, as well as motivated as it relates to his sexual orientation. It turned out he had paid a couple of actors to beat him up, and because of apparently who he was, an actor on the series Empire, someone in his family spoke with the prosecuting attorney, the district attorney there in Chicago. So Jussie Smollett got a smoking good deal where he had to perform 16 hours of community service, agreed to forfeit his $10,000 bail, and did not admit any guilt. Needless to say, this caused an uproar, okay? Even defense attorneys, one like myself, were shocked and appalled as a member of the community because, man, if that was a great deal, that would be an understatement. That was a huge deal. But just like when people always try to get a little sneaky, there's usually an investigation. So it turned out that the prosecutor in this case, the district attorney, Kim Fox, stated that she had recused herself because she had spoken with this family member. So to avoid any appearance of impropriety, she was going to step back. Well, normally when a special prosecutor is appointed, that prosecutor's office is completely out of it, okay? It's done. They keep clean their hands and say, we're appointing a special prosecutor, and so another jurisdiction completely takes over, and they have complete authority and control as to what takes place. Well, Ms. Fox didn't do that in this particular case. She appointed her deputy, which was really the same office, and therefore did the deal. So she never really had recused herself. So in a legal opinion that the court wrote about this situation, basically said there could be no deal with Smollett because there was no prosecutor at the helm of the ship, so to speak, because the prosecutor had never recused herself, or she said she had, but she had just appointed somebody, and so there really wasn't a prosecutor. There was no jeopardy issues in this particular case because really there was no case and there was really no dismissal according to the court rulings. Now Mr. Smollett will face some 16 felony charges in this indictment. He's already being sued by the city of Chicago for the cost of the investigation, which was about $130,000. We'll see who ultimately gets appointed with the special prosecutor this particular time. And somehow I think Mr. Smollett is not going to receive the deal that he received before. Now, the two actors, the two brothers that Mr. Smollett allegedly paid some $3,500 to participate in this little scheme, they are still on board. They apparently are still cooperating with the police and want the truth to come out. They too have attempted to sue Mr. Smollett for basically defamation that Mr. Smollett has caused to them and their reputation. So we'll see. Next on the docket, Micheal Avenatti. Yes, everyone knows Micheal Avenatti, the attorney that even attorneys don't like. Mr. Avenatti made a big name for himself, represents very high-profile clients. Mr. Avenatti just had a real problem. He was not looking out for his client's best interest. He was simply looking out for his. And that is what brings us to Mr. Avenatti's extortion case. He represented a basketball coach who thought that there were some illegal improprieties taking place by Nike paying sports coaches fees and giving equipment and things of that nature. Mr. Avenatti has tried to settle that case with Nike for his client, but he failed to disclose to the client that Mr. Avenatti was going to take it upon himself and do a kind of an internal investigation for, $20-25 million. It's Nike. What's that? It's a drop in the bucket. They probably make that in less than a few hours. That's something that should have gone to the benefit of the client, not negotiating future payment for yourself, even if you're saying you're doing an audit. The attorneys for Nike immediately called the U.S. Attorney's Office. They have Mr. Avenatti on audio recordings, basically laying out what he wants and that it's clearly extortion. We will ultimately have to wait and see if the jury believes that this is extortion or whether this was just hardball lawyering for the benefit of his client and the fact that Mr. Avenatti was going to get some work out of it on his own. Maybe no harm, no foul. Now, Mr. Avenatti, as you may recall, was arrested in California for basically violations of his pretrial release conditions. But although they delayed his trial a week in California, they got him to California to stand trial. Closing arguments, the prosecutors played the tapes and said, this is what extortion sounds like. Mr. Avenatti's defense was somewhat limited because he wanted to call various executives to the stand, and the judge said no, there's no relevance whatsoever, and it has nothing to do with extortion, whether attorneys and people at Nike had a conflict of interest as to whether this was in fact extortion. So the defense case was brief. Mr. Avenatti did not testify, and so we shall wait and see what happens to Mr. Avenatti. He still has two other federal cases pending, one in New York and one in California for allegedly stealing his client's money. You may recall he was arrested while he was at his California bar hearing as they were trying to present testimony to suspend his law license when the warrant was executed for his arrest. So Mr. Avenatti definitely not having a good couple of months here. We'll see if it gets better for him. But he still has two more cases to beat. One case is tough to beat, let alone all three. Next on the docket, Harvey Weinstein's trial is finally coming to an end. My goodness, it's like attending a class in college, that was 3 hours worth of material spread over 6 weeks. This thing just would not end. But the defense finally rested today. They'll begin closing arguments, and then the jury will ultimately get it. Obviously, Harvey Weinstein is the poster child for the #MeToo movement, and their defense for Mr. Weinstein has simply been that he's had sex with all of these ladies and it was in fact consensual. The strongest argument that they have is that all these ladies had a continual relationship with him for years and years after the alleged inappropriate conduct. We're going to have to wait to see whether the jury believes the prosecution's story, that these were unwanted, non-consensual sexual assaults, or whether these were consensual encounters, and you may not like Harvey Weinstein, but he did nothing that was illegal. We're going to have to wait to see. I really don't know how this one is going to turn out. It could go either way. There are 7 men and 5 women on his jury, and we will see what they ultimately decide. I've been a firm believer in cases like this that women are the best jurors for a male defendant in a situation like this. A lot of people don't agree with me, but the reality of it is my experience has been that women are more harsh and more judgmental towards other women than they would be, for example, men. We'll see. We'll see whether the men think, wow, this could have been me. We don't like him, but it's consensual. And, regardless of all the experts that have come in to explain why the victims in this particular case had this ongoing relationship, even after they said they didn't want to, but they kept reaching out to him, wanting to date him, go to parties, looking for work from him. That's going to be a tough sell, I think, for the prosecution, but you just never know where this one is going to go. Next on the docket, Fotis Dulos' attorneys have been threatened. That's right. Norm Pattis and Kevin Smith have been representing Fotis Dulos until his untimely demise at his hand. And apparently a young man by the name of Adam Davenport, 31, is basically being charged with threatening the attorneys. Apparently he got quite active, and one evening on September 5th, he made some calls. Then again on October 15th, he called Pattis repeatedly at 8:19, 8:21, 8:24, 8:30, 8:33, 8:36, 8:45 p.m. And then he called Smith about 3 times as well. Normally, this is not a big deal. I think most criminal defense attorneys who have handled any type of a big case or something that people just don't like, it gets some social media attention, you're going to get the crank callers who call up and say, you're a terrible person. Okay, thank you. Have a nice day. Click. All right. And apparently that's what Pattis and Smith basically thought, oh, it's no big deal. But this particular case, they took the threats seriously because they kept saying Smith is not safe and it's going to be real easy, man, real easy. So he did, Mr. Smith did what most people would do in that particular situation, which would simply be, hey, let's call the cops, make a report. And oh, by the way, we have the guy's phone number that he called from. Okay. So what do the police do? They go and talk to young Mr. Davenport, who admits to it. Oh, funny enough, he also admits to basically being down on his luck. He's unemployed. He was drinking that particular evening and obviously doing some drunk dialing of these individuals. He expressed remorse and would like to apologize to all involved. Little legal advice here, all right? Little unsolicited, free legal advice. Don't call people that don't want to talk with you, okay? Particularly repeatedly. Most telephone harassment statutes, ordinances, simply say if you repeatedly call somebody, that's harassment. If somebody tells you, stop calling me, guess what? The next time they do that, that's harassment. You can call the police. You can be arrested for that. And if it's a ex-boyfriend, girlfriend, it's going to be a domestic violence case. Like, just don't go there. If people don't want to talk to you, don't talk with them. It's that simple. Now, Mr. Davenport, not only is he down on his luck and has a job, no money, now he's going to face criminal charges and be in further in debt because he wanted to talk to people that didn't want to talk to him. Let it go, man. Let it go. Next on the docket, Brandon Clark, 21, pled guilty for the death of Bianca Devins, 17. He stated in court on his plea that he felt sorry for what he did and that Bianca didn't deserve anything that happened to her. Now, people may not recall Mr. Brandon Clark's name, but they may recall what he did. Apparently, after Miss Devins had passed, Mr. Clark put photos up on Facebook Live, and it obviously was taken down and just completely inappropriate. And when Mr. Clark was arrested, he began stabbing himself in the neck himself, and then they found Miss Devins' body underneath a green tarp. In exchange for his guilty pleas, Mr. Clark had 2 contraband cases dismissed. Apparently, he had some sharpened toothbrushes in his cell, and obviously that's contraband, and that is an offense that can be prosecuted, and frankly, who cares? The man's going to prison for murder. let him have his toothbrushes, or at least don't prosecute him for it, if that's what it means to resolve the case. Next on the docket, Roger Stone's prosecutors resign. So 4 federal prosecutors in the criminal case against Republican operative Roger Stone dramatically quit today. The move came shortly after the Department of Justice said it will force prosecutors to cut their recommendation that Stone, a longtime ally of President Trump, serve as long as a 9-year sentence in prison. Although it's highly unusual for the Justice Department to reverse a sentencing recommendation after it's been made by the prosecution, the ultimately decision relies upon what Maine justice wants. So Mr. Stone went to trial and was convicted of all counts alleged in the indictment. Stone was convicted for lying to Congress and making some threatening allegations to another compatriot that he said he would threaten to kill his dog. And this individual ultimately said, I didn't really think that he was going to kill my dog, but he testified as such. Needless to say, Stone was convicted. Now, in the federal system, when somebody is sentenced, the first thing you have to do is go to the federal sentencing guidelines. And they are one factor. These things used to be mandatory, but then the Supreme Court said, no, they're only one factor that one must consider under 18 U.S.C. 3553A sentencing factors. And basically, you look at each offense that is given. It has an offense level. Then you go to another little table, and it determines one's criminal history. And that's where you come down on some little chart, offense level criminal history, whether you're a 1 or a 6, that's where you come out. It used to be mandatory. Rarely could you get a sentence that was below that. But the sentencing is ultimately with the judge. Now remember, we have a federal judge here who receives sentencing recommendations, okay? That's all it is. You look at the federal sentencing guidelines where we think somebody should be. Then you listen to recommendations by the prosecutor, who could ask for the statutory maximum, or you could ask for, or you can listen to the recommendation from the defense, which would say, Judge, give him as little time as possible. Frankly, he doesn't need any at all. Just send him on his way. Okay? That's a recommendation. So I don't understand why these prosecutors are all getting hot and bothered about their boss telling them, you're going to change your recommendation. I get it. You're lying AUSA, and you feel jilted that somebody told you to change it. Well, guess what? You work for the government. You work for the Department of Justice. Ask any United States attorney what gets done without Maine justice approving it. Little to nothing, all right? Most plea agreements of cases that have been indicted go through Maine justice. Before you file a case, it all goes through Maine justice. Before they file a wiretap, it goes through Maine justice. Nobody makes a move at any U.S. attorney's office unless it's been blessed by Maine justice. So these prosecutors who are resigning, okay, 3 of the 4 are going to continue to be attorneys at the Department of Justice. Well, if you're so outraged and incensed, just quit completely. At least one had enough guts to say, I'm not going to work for the federal government anymore. If you're that outraged and incensed, go do it. It's called you work for somebody. And guess what? Now, this all came about because apparently the president made a tweet that he thought that this was an excessive sentence. Okay, guess what? He's a politician now. He can say what he wants. It's ultimately with the judge. And the judge isn't going to be influenced by somebody's tweet. Remember, federal judges sit for life. They don't have to be subject to voter approval every few years. They've been approved by the Senate. They have a job for life. Unless they commit an impeachable offense, they're there. They don't make decisions based upon what somebody's tweet may have been. So I don't see what the big deal is. Somebody's boss told him, go do something and recommend a little less time on a sentence. Who cares? It's just a recommendation that goes to the judge. It's not like it's binding on anybody at all. So anyway, I think everybody's making too big a deal about it. If these prosecutors are that offended by it, like I said, quit. But don't just quit this particular case. And frankly, I'm a little surprised that they could be permitted to just quit being on this particular case. Frankly, the U.S. attorney that would handle them, and they all serve at the pleasure of the U.S. attorney, fire that guy if he doesn't want to prosecute the case in accordance to the way his boss wants it to be done. It's just reality, ladies and gentlemen. There's lots of things I have to ask for in front of judges because that's what my client wants. Even if I don't like it, even if I think it's going to be denied and make me sometimes lose credibility, sometimes it's easier to ask for it so the client is happy than it is to not do it. It keeps those good relationships going so the client understands you are fighting for them. Like, these guys should have just gone in, do their job. The judge already knows what their original filings were. Like, get over it, man. Next on the docket is our dumb criminal of the day. And this dumb criminal contestant of the day is now a former postal worker. And why could this individual get in trouble? Well, let me tell you. Jason De La Cruz, who was working as a postal carrier in June of 2018, has ultimately pled guilty to the charge of delaying the delivery of mail. He's ultimately resigned from the United States Postal Service and is facing prison time. Now, Mr. De La Cruz's scheme was disrupted when he was spotted unloading mail into a public storage facility in Virginia Beach, Virginia. A witness apparently snapped several photographs of the postal employee and the picture of the license plate of the employee's vehicle and provided the images to the postal officials. When confronted by federal postal investigators, De La Cruz says he can't make time and felt pressure to complete his route, but he was unable to do so. He then admitted to renting the public storage unit for $49 per month for the sole purpose of storing mail that he could not deliver. Yes, delaying the mail is a federal offense, and you cannot do that when you work for the Postal Service. Now, this individual faces a possible penalty in the Bureau of Prisons, and he may just get it. Because let me tell you a quick story when it comes to postal carriers. Years and years ago, I had a client of a very similar charge, a contract employee for the mail service. And he would go through and sort people's mail and decide if it was junk mail or not, and figured these people didn't need the junk mail. Well, what would he do with the junk mail? Would he throw it away, saying it's junk mail? They don't need it? No, he would save it. Ultimately, this came about because somebody saw all of the mail in his vehicle and it wasn't being delivered, and he was charged with not delivering junk mail. And of course, I'm in front of a judge, and man, this was Judge Meach, the Oklahoma City bombing judge. He just recently passed away here about 2 months ago, but he was a great, great judge. He didn't take crap from anyone and didn't waste anyone's time, and he also reversed a $17 million judgment I had once, but I'm not bitter. So we're there for sentencing, and he was one of my first federal clients who ever was eligible for probation, and asked the judge for probation. Judge, is just junk mail. What's the big deal? And Judge Meach had come from small town here in southwestern Colorado and was rather shocked and appalled that I was making such an argument, because where he comes from, people expect their mail to be delivered. People rely upon the mail to be delivered. And if the mailman can't be trusted to deliver the mail, he needs to be punished. Ultimately, the client was sentenced to 365 days in the Bureau of Prisons. I then asked for, Your Honor, could he have 365 days plus 1 day? Why, you ask? Because then he gets good time credit. Otherwise, he had to serve the entire 1-year sentence. So whenever clients ask, do I think I'll get probation in federal court? Normally, no, because you've gone to federal court, you've hit the big time. And second of all, I tell them that story. Never plan on probation in federal court. This particular postal carrier, Mr. De La Cruz, dumb criminal, just delivered the damn mail, for God's sakes. He won't be doing that, obviously, anymore. But just do your job, man. Take the mail back and do it the next day. Come up with a new plan. Don't hoard people's mail in the storage unit that you put out at your own expense. That's just dumb. Thanks for watching. Leave a comment. Let me know what you think about Jussie Smollett. Do you think justice is being served by re-indicting Mr. Smollett? Do you think Mr. Avenatti stands a chance? What do you think is going to happen to Harvey Weinstein? Guilty or not guilty? And if you have any comments on Roger Stone's prosecutors quitting, let me know. Leave a comment. Thanks for watching. Have a great day. We'll talk to you next time on Crime Talk.